So we were dealing with part 15 of the constitution which deals with elections, and basically we divided our discussion into two. We had discussed what is the objective of part 15, the objective being the ensuring free and fair elections. For that there is two aspects of our discussion. First is organization of elections and the second is election commission. We had taken up our discussion on organization of elections, and we had seen that here, that means in organization of elections, we had seen article 325, 326, 327, 328. That is article 325 of the constitution talking about a single electoral roll, article 326 talking about the right to vote, article 327 of the constitution empowering the parliament to make a law regulating elections in India, and article 328 which dealt with the authority of the state legislatures with respect to the laws, electoral laws. We had also seen that the state legislature is only empowered to make such a law, such a law if there is either absence of a law made by the parliament, or for that, that means there is no law there, or there is the law that is made by the parliament is insufficient. In these two conditions, the state legislature is empowered to make a law which regulates elections in that state. Next comes article 329 of the constitution, which deals with, write down, it bars the interference of court in electoral matters. Under article 329, laws made by the parliament with respect to delimitation or allotment of seats cannot be questioned in any court of law, in a court of law, not any, right, a court of law. Similarly, no elections to either house of the parliament or state legislature can be questioned except in a manner as provided by law enacted by the parliament or state legislature. Accordingly, the Representation of People's Act provides that an election dispute petition can be filed only before the respective high court after declaration of official results. See, article 329, what is the objective of article 329? The objective of article 329 is that when it comes to electoral laws that are there, or for that matter any specific decisions which regulates elections, or challenging the result also, challenging the election also, if it has to be done, it has to be done by or in accordance to the mechanism that has been provided by a law enacted by the parliament. So I cannot, as an individual, I cannot automatically challenge an election, or for that matter, I cannot provide an election petition until unless I follow what is the procedure that has been mentioned in the law. What has been mentioned in the law, and accordingly it says, the law, the Representation of People's Act says, suppose I have to challenge the election of to the Lok Sabha or to the state legislative assembly in this state, so I will file an election petition for this, and that petition will be filed not in the lower court, it will be filed in the high court, and only after the election results had been declared, not before it, not before it. The procedure that has been mentioned under the Representation of People's Act. So the court is barred from interfering in electoral matters except for the manner that has been provided in accordance to law. It does not mean the court has been barred from interfering in any matter. No, it can interfere, but the interference that the court does in electoral matters, it will be done only in the manner that has been mentioned in the law. Clear? This is Article 329 of the Constitution. Like, if suppose, just an example, recently general elections were conducted. So there were lot of issues here. Like, one of the issues was with respect to an individual who was contesting elections. He was contesting elections. He was given the nomination from the this particular constituency of Varanasi, where our Prime Minister is an MP from. So initially the nomination there was given to whom? The nomination of the Samajwadi Party and the BSP, because they were in a coalition there. So it was given to an individual. It was given to an individual called as Tej Bahadur Yadav. He was an individual who was dismissed from service on the ground that he was from CRPF. He initially had a job in CRPF. He had actually made a social media video. His video went viral, wherein he had claimed that the members of CRPF who are serving in such areas do not get proper food, etc., etc. On that ground, because it was a violation of code of conduct, he was removed from service. He was the one who was given the party's ticket, and he was not able to produce a document which is mandatory under the Representation of People's Act. So any individual who is removed or dismissed from service under the government, he has to produce a certificate of the Election Commission saying that he was not dismissed or removed from service on what grounds? On criminal grounds. On criminal grounds. So he has not, he is not convicted under a criminal offence. So he has to produce that certificate. He was not able to produce that certificate. His nomination got rejected, and he appealed this in the court. But how was it done? It was done after the election results were declared. After that, he filed a petition in the concerned court. So it's not to say that the court is completely barred. The court can come, the court can interfere, but only in the manner in which it has been mentioned under the law that has been enacted by the Parliament. In this case, it is Representation of People's Act. Clear? This is what is Article 329. With this, we complete our discussion on organization of elections. Next, we move to this idea, that is Election Commission. So give a subheading here, write Election Commission of India. Election Commission of India. Under Article 324, Clause 1, Clause 1, a common election commission. A common election commission for both the center and the state. For both the center and the state has been provided an autonomous status, that is independent of the executive and legislature. Executive and legislature to conduct a free and fair elections. Free and fair elections. So there is an autonomous body that has been created under the Constitution, which is free from any kind of influence of the executive or the legislature, so that in India what we have is a body conducting free and fair elections. Free and fair elections. This is very important because recently there has been a lot of claims about the the non-independence of election commission. There has been number of claims about the non-independence of election commission. The opposition parties have claimed that the election commission has not worked well in this general elections. They are biased. They have been biased towards the ruling party. The ruling party has also claimed that the election commission has not been able to perform functions well. The reason being what has happened in the state of West Bengal, the kind of violence that has happened during elections there. So the election commission right now is under a scrutiny from both the opposition party and also the ruling party. The opposition party claims that the election commission helped the ruling party. It overlooked certain violations of model code of conduct that is there by the ruling party. On the other hand, the ruling party claims that election commission was inefficient, specifically when it comes to the state of West Bengal, because of the kind of violence that happened there. So there has been, this particular body is under scrutiny as of now. So when we look at the composition of this particular commission, we have to see what is the composition and what is the conditions of service of the members of election commission, to understand whether this body is whether it is completely free from the influence of the executive or not, because this is what has been claimed by the opposition, that this body is not acting. They are not acting as a fair and a neutral body. They are not acting as a fair and a neutral body. So let's look at that very idea when we see the composition and when we come to conditions of service. First, give a subheading, right? Composition. Under Article 324 Clause 2, under Article 324 Clause 2, the Election Commission shall consist of one chief election commissioner, and such number of other election commissioners as may be appointed by the president. Subject to law made by the parliament in this regard. Underline this: subject to a law made by the parliament. What does this provision mean? This provision means that if you see who decides that there is going to be this Election Commission of India is going to be a multi-member body. In this case, it is generally decided by the President. But if there is a law that is enacted by the Parliament, in that case, it is the Parliament who decides. But in absence of a law enacted by the Parliament, in that case, the authority lies with whom? The President. So, when we say subject to a law made by the Parliament, what does that mean? It means that if the Parliament passes a law, then it is up to the Parliament. But in absence of a law made by the Parliament, it is the President who will appoint number of other individuals to become election commissioners, because there will be one election commissioner. That is what the Constitution says. There shall be one election commissioner and any other number of election commissioners. So when it comes to one election commissioner, that is the chief election commissioner, that individual, that office is mandatory, it will exist. But how many other number of election commissioners are to exist, it is dependent upon a law that is enacted by the Parliament. If there is no law, then it is dependent upon the President. Accordingly, till 1989, Election Commission was a single-membered body. Election Commission was a single-member body. Till 1989, it was a single-member body. However, in 1989, in the last class we had seen how the age was decreased from 21 years to 18 years. So previously the original constitution allowed the right to vote to an individual who had attained the age of 21 years. So in 1989, if you go back to our discussion when we were talking about defining the term adult, in that case we said that post the constitutional amendment it is 18 years. So in 1989, there was a constitutional amendment, and through this the age was reduced to 18 years from 21 years. And this was the first time when Election Commission became a multi-membered body. It became a multi-membered body. However, since 1991 till today, it has consistently been a multi-membered body. Consistently. Why? Because in 1989, there were 2 additional election commissioners who were appointed along with the one chief election commissioner. After the 1989 general elections, the situation was reverted back to the original condition, wherein only one chief election commissioner was there. But again in 1991, it was appointed as a multi-membered body, and since 1991, it has been continuing as a multi-membered body. Since 1991, it has been continuing as a multi-membered body. Clear? Have you understood this idea? See, 1989, it for the first time became a multi-membered body. But after the general elections of 1989, again the 2 other members that were there, they were removed, and again the Election Commission reverted back to a single-membered body. But again in 1991, it became a multi-membered body, and since then it has been a multi-membered body. Clear? Now, give a subheading here, write Chief Election Commissioner. Chief Election Commissioner. CEC. Chief Election Commissioner. He is appointed by the president. He is appointed by the president and is removed in a manner as the judge of Supreme Court. Judge of Supreme Court. Underline this. Judge of Supreme Court. So when we come to the judiciary, we are going to discuss removal of judges. There you will understand that the mechanism is that the Article 124 of the Constitution lays down that a judge of the Supreme Court is to be removed. How? A judge of the Supreme Court is to be removed on a ground. What is the ground? Ground is incapacity or misbehavior. And how this incapacity or misbehavior is established? It is established in the parliament if both the houses of the parliament pass a resolution by a special majority, and the president signs the order of removal in the same session in which the resolution has been passed, then the judge of the Supreme Court is removed. So that is also true for the Chief Election Commissioner. So he is to be removed how? He is to be removed on the same grounds. So incapacity or misbehavior. And how? What is the process that is mentioned? According to Article 124, there is a resolution to this effect if it is passed by a special majority from both the houses, in both the houses of the parliament. Clear? If it is passed in both the houses of the parliament and the order of removal is signed by the president in the same session, which means if the parliament has passed it in the budget session, so it will be signed in the budget session. If it has been passed in the monsoon session, so it should be signed in the monsoon session. If it has been passed in the winter session, so it has to be signed in the winter session. It has to be signed in the same session. If the session is over, then that order of removal will have no meaning. This is the mechanism through which Supreme Court judge is removed, and this is also the mechanism through which the Chief Election Commissioner is removed. Clear? Further, right? His conditions of service cannot be altered to his disadvantage. All the other service conditions are to be regulated by the parliament. Underline this, parliament. So the constitution is very clear. It says the Chief Election Commissioner, what are the conditions of service? It is to be regulated by the parliament. And the constitution also says that his service conditions cannot be altered to his disadvantage. So बढ़ा सकते हो, घटा नहीं सकते हो. You cannot decrease his salary, pension or conditions of service. You can increase it, but you cannot decrease it. Clear? Accordingly, because the power to regulate it lies with the parliament, so there has been a law which has been passed by the parliament. Law says the Chief Election Commissioner, Miscellaneous Provisions Act 1951. This is the law that has been passed by the parliament to regulate the service conditions of the Chief Election Commissioner. Clear? So what are the conditions of service that are laid down by this particular law? Let's look at that. Chief Election Commissioners Miscellaneous Provisions Act 1951. Miscellaneous Provisions Act 1951. First, in order to be qualified to be appointed as, in order to be qualified to be appointed as the Chief Election Commissioner, a person shall be well versed in the field of administration. Well versed in the field of administration. So he should have considerable experience in the field of administration. This is what it means. When we say well versed in the field of administration, it means he should have considerable experience here. Second, the Chief Election Commissioner is appointed for a term of 6 years, or until he attains the age of 65 years, whichever is earlier. Third, so 6 years or 65 years of age. So whichever is earlier, if he attains the age of 65 years before completing 6 years, he retires. Next, after his retirement, he cannot be reappointed. Nor is he eligible to hold any office of profit under the state. So he cannot hold any office of profit under the state. Next, his salaries, allowances, pensions are charged on the Consolidated Fund of India, and cannot be reduced except in financial emergencies. And fifth, he enjoys the status of a judge of Supreme Court. This is the conditions of service that is there. Underline charged on the Consolidated Fund of India. Underline that. Very important. Clear? Next, give a subheading, right? Other election commissioners. So this is with respect to the Chief Election Commissioner. Now let's come to other election commissioners. They are appointed by the President. Under Article 324 Clause 2. And can be removed by the President. On the recommendations of Chief Election Commissioner. Underline this provision. On the recommendations of, removed by the President on the recommendations of Chief Election Commissioner. The Parliament has enacted the Election Commission brackets conditions of service of election commissioners and Transaction of Business Act, Transaction of Business Act 1991, which provides for the following, which provides for the following. First, the Election Commission shall consist of one chief election commissioner, and not more than 4 other election commissioners. Not more than 4 other election commissioners. Second, in order to be appointed as the election commissioner, one must be well versed with the field of administration, Third, he is appointed for a term of 6 years, or until the age of 65 years, whichever is earlier. Next, the election commissioners are eligible to be appointed as the chief election commissioner, provided the number of years he has served as the election commissioner and chief election commissioner shall not exceed 6 years. He is further ineligible to hold office of profit under the government. Next, he enjoys the status of judge of election commission, a judge of Supreme Court, status of judge of the Supreme Court. Next, all the members of election commission shall enjoy equal powers and voting rights. Therefore, decisions taken in the election commission are on the grounds of unanimity or majority. Underline this. Now, come back to our discussion on the office of Chief Election Commissioner, and let's compare this office to the other election commissioners. The Constitution says that the Chief Election Commissioner is to be appointed by the President, and other election commissioners are also to be appointed by the President. When it comes to the removal, of Chief Election Commissioner, the Chief Election Commissioner is to be removed in the same manner as the judge of the Supreme Court. But how are the other election commissioners being removed? They are being removed by the President, not on the grounds or not in the manner as the judge of the Supreme Court. They are being removed on the recommendation of the Chief Election Commissioner. They are being removed on the recommendation of the Chief Election Commissioner. Secondly, if you look at the Constitution nowhere mentions what is the qualification of the Election Commissioner or the Chief Election Commissioners. It does not mention any of such thing. Neither does the Constitution mention that the expenditures of the Election Commission are to be charged on the Consolidated Fund of India. Neither does the Constitution mention what is going to be the terms and conditions of service. It is up to the Parliament. So even the Election Commission the Constitution does not define, okay, 6 years or 65 years. This is not mentioned in the Constitution. It is mentioned, it is given in accordance to, or it is dependent, completely dependent upon a law made by the Parliament. If we look at these provisions, that is the election commissioners being removed by the President on a recommendation of the Chief Election Commissioner, the expenses, salaries and pension of the body Election Commission not to be charged on the Consolidated Fund of India in accordance to the Constitution, that has not been mentioned, and conditions of service is to be determined by the Parliament of India. If you stitch all these provisions together, what do we conclude? What we conclude is that this body, the Election Commission of India, which is supposed to be which has to be one of the most neutral bodies and should not be under the influence of the executive, is under the influence of the executive. Why? Because the members can be removed by the election commissioner, the Chief Election Commissioner, or recommendation of Chief Election Commissioner by the President. And conditions of service are to be determined by whom? By the Parliament. So the Parliament may authorize even the Government of India to determine the conditions of service. Can it do it or not? Can there be a law passed to it? Do you know what are the changes that have happened in the RTI law in 2019? What are the changes that have happened? Service conditions and remuneration. This has been changed. So previously a body called as the Information Commission, the Central Information Commission and State Information Commission, a body which had these provisions that they will be serving for 65 years or 6 years or 62 years or 6 years, and they will be free from the influence of the executive. There were all necessary provisions were made under the RTI law. All necessary provisions were made under the RTI law. But what happened? Because it was completely up to the Parliament, so in 2019 it was amended. And now, who decides the conditions of service? It is the central government. So it's not 6 years or 65 years or 62 years anymore. It is completely up to the central government. To an extent wherein the RTI law also says, previously, if you see the 2005 law, in the 2005 law, it was mentioned that an information commissioner, once he retires as an information commissioner, he is disqualified to hold any office under the union, under the state, or for that matter in these public enterprises. He was not anymore to hold such offices. That provision has been removed. And today an individual who is an information commissioner, retires as an information commissioner, can be appointed to such offices. When you do not make such provisions in the Constitution, what are you doing? You are allowing the organization, in this case the Election Commission, to be under the influence of the executive. And that is the reason. That is the reason why the body is criticized. Now, the body is criticized not only by the opposition, but also by the ruling party. They are also being criticized. मतलब this body has nowhere to go. ना ही वो claim कर सकता है चलो opposition ही तो criticize कर रहा है. तो एक वो होता है कि okay, they are losing elections, so they are criticizing the body. That is also not the case. Why? Because the body has also been criticized by the ruling party for their conduct and their manner in which they have dealt with what happened in West Bengal, the kind of violence that happened in West Bengal, and the body not being able to, the body not being able to properly regulate it or in any manner curb any kind of violence. That could not be done. Why? Because if you look at the provisions of the Constitution, unlike, go back to our last class's discussion on Public Service Commission. We said when we were talking about the independence of the commission, we specifically mentioned this idea that the expenses are charged on the Consolidated Fund of India. That is not the case when it comes to Election Commission. The Constitution does not mention that. It is only mentioned under a law made by the Parliament, not under the Constitution. Similarly, the Constitution nowhere mentions what is the conditions of service. It does not mention what is the qualifications. And all of this does what? All of this makes the body, that is the Election Commission, very much under the influence of the executive. So until and unless we make some constitutional changes to allow for the independence of this body will always be scrutinized and criticized by the, not only by the opposition, but even maybe by the ruling party. Even maybe by the ruling party. And you can see this very idea of what happened when it came to the EVM issue. When it came to the EVM issue. So when EVM was being questioned, the Election Commission, whatever Election Commission was doing to defend itself, it was never found to be, sufficient. Why? Because the body is under the influence of the executive. Like the CBI. CBI will always be, criticized of its use. Why? Even if the CBI is working with complete independence, with complete freedom, with no influence of the executive, but it will always be criticized to be a caged parrot or a parrot. Why? Because it will speak the language which it is taught by the union government. It will always be criticized on that grounds. Why? Until unless we come out with a law providing independence to such a body. That is also the case with Election Commission. Election Commission may be truly an impartial body, an independent body, the executive may not interfere with this, but it will always be criticized by the opposition. So, the best way, not accepting defeat in the election is what? Criticize the Election Commission. EVM faulty hai. It's a very easy mechanism to do, and that is something that is, there has been number of study done on the Indian EVM. There has been a number of studies that have been done on Indian EVM. There have been what you can say case studies on Indian EVM, because because of this very idea of it is something that cannot be tampered with. So even in US, when elections are being conducted, they use Indian EVM. Not all of it, because there still ballot paper is going on. In US, still ballot paper elections are going on. So wherever it is feasible, the EVM that they use, it is manufactured by us. It is us who provide them the EVM. There have been number of studies on it, and it has been claimed that EVM is not tamperable. It cannot be tampered with. See, I am not saying it does not malfunction. It malfunctions because it is obviously an electronic device. So it will malfunction. But saying that it has been tampered with is absolutely wrong. It is absolutely wrong. But still you can see that this will be questioned. Why? Because the constitution, the manner in which the election commission as a body has been conceived here, it has been conceived as a body which is under the influence of the executive. Why? Because we have not made some very basic changes to the constitution which we should have done long back, like ensuring that the election commissioners, that is other election commissioners, given the same kind of constitutional protection as the chief election commissioner has, that is to be removed on the similar grounds as the judge of the Supreme Court. Because if you see, if you look at the law conceives that the election commission, every member of the election commissioner, whether it is the chief election commissioner or other election commissioners, they have the similar status. They do not differ. So an individual who is called as the chief election commissioner, though he is given that particular membership, that he is acting as the chairman of this election commission, but it does not mean he has a special status. He enjoys the same kind of powers, the same kind of status that of other election commissioners. And that is the reason why you have written that decisions taken here are either taken on the grounds of unanimity, which means everyone accepts it, or it is taken on the ground of majority. So even if two election commissioners, they agree to a decision, even if the chief election commissioner does not agree to it, it will still, that will be the decision that will prevail, that is two election commissioners. So this body does not, they do not differentiate in terms of the conditions of service and the provisions in the position of election commissioner and chief election commissioner. When that is not the case, there is no logic. There is no logic to continue with this idea of the chief election commissioner being removed on the grounds and the manner of the Supreme Court judge, and the other election commissioners being removed on the recommendation of the chief election commissioner. There is no logic to this very idea. Hence, this should be amended. Other election commissioners should be given the same kind of constitutional protection. Second, the Article 324 should also be amended to do what? To include the provision that the expenditure of the election commission should be charged on the consolidated fund of India, which it is not right now. It is only mentioned under the law. That should also be changed. And there should also be an explicit qualification, because this constitution does not talk about the qualification of election commissioners or the chief election commissioners. So explicitly we should amend Article 324 and add for a qualification that if you can write it in a law, well versed in the field of administration, you can do what? You can quantify it, like we have done in case of Public Service Commission, 10 years of service under the government. So you can include any such qualification here as well, 10 years or 20 years, because election commission is such a body that you are appointed to when you are in that super senior scale. So you can include 20 or 25 years of service under the government of India. And when you do this, only then we see the Election Commission of India being a truly independent body without any kind of influence under the executive or the legislature, like the Comptroller and Auditor General. You can see the Comptroller and Auditor, the office of Comptroller and Auditor General is not criticized in the same manner as the Election Commission. Why? Because it's truly an independent body. So the same status we have to give even to Election Commission. Why? Because obviously it is the institution in the under our constitution which is responsible for protecting the very democratic system that is present in India. For a time period, even if you just assume that though this is not the case, I am telling you this is not the case, because there has been number of issues with the EVM that have been talked about. In the Delhi Legislative Assembly, there was a full-scale discussion wherein there was an individual showing how the EVM can be tampered with. Election Commission went to an extent wherein they because of this regular acquisition, alleged tampering with EVM that was going on. So the Election Commission went to an extent wherein they issued an open challenge. That was something that has for the first time happened under the political system of India. What they did was they actually decided a date, that this 10 days that is there, they issued an open challenge that EVMs that are there in India, it will be present. If any individual or an institution has the capability to hack it, they issued an open challenge, but no institution went there. So no institution took actually tried it also. But when it comes to the Delhi Legislative Assembly, so the government of Delhi, they come up with they dedicate a legislative session on how EVM how EVM is being hacked. And similarly, the Congress party did the same thing. But how did they do that? They took this issue up in London. That is further delegitimizing the elections of India. They went to the other country, and there were some political members of the Congress party talking about the elections, the EVM being hacked, and there was an individual who was actually showing how it can be done. But when Election Commission of India tells it to do in India under the supervision of Election Commission, no political party or an institution even tries it. Why is this the case? It's not because there is a problem with the EVM. That is not the case. The problem is with the constitutional provisions. If we allow for independence of this body, in that case, no one will question the very independence of Election Commission. No one will question that. In post-elections, I was going through the news that day itself when election results were announced. So there was one of social media YouTube channels that are there, which is like a news channel they have come up with, and there was a discussion going on there. So I was going through that discussion. I was listening to it, and one of the journalists went to an extent wherein they said that a question was asked to him that what do you think, who should be who is responsible for such of a electoral victory of the BJP? So he said the BJP should congratulate the Election Commission. The BJP should congratulate the Election Commission because Election Commission worked in their favor. So after the results are out, you tend to hear such things. It delegitimizes a constitutional body. And to ensure that this does not happen, there is a need to do what? Amend the constitution and provide for its independence. Clear? Next, give a subheading here and write regional commissioners. Regional commissioners. See, when we say the service conditions cannot be altered to their disadvantage, it means that when the individual is in office, it cannot be altered to its disadvantage. That is absolutely fine. But you can still vote upon the expenses of not the Chief Election Commissioner, but definitely the expenses of the Election Commission. So that can be used as a mechanism. So there is a need to ensure charged on the Consolidated Fund of India. No voting, no influence of the executive or legislature. Regional commissioners, right? Under Article 324 Clause 4, the President, on the recommendation of Election Commission, can appoint regional commissioners on the eve of elections to assist the Election Commission to assist the Election Commission in conducting free and fair elections, They are not the members of Election Commission. They are not the members of Election Commission, and they can be removed by the President. They can be removed by the President on the recommendation of the Election Commission. On the recommendation of the Election Commission. So there is a provision for appointing regional commissioners as well, but this provision has not been used in India. So we have never appointed for a regional commissioner. Clear? Give a subheading, right? Functions of Election Commission. Functions of Election Commission. First, the superintendence, direction and control. The superintendence, direction and control of the preparation of electoral rolls, for all elections to the Parliament, and to the state legislatures, and to the office of the President and Vice President, Underline superintendence, direction and control. Second, conduct of all the above mentioned elections. Third, advising the President and the Governor. On the question of disqualification. On the question of disqualification as a member of Parliament, or a member of state legislature. And as a member of state legislature. Under which article does the Election Commission does this? Under which article? Yes? Article 102 of the Constitution. Article 102 of the Constitution explicitly says disqualification of members, and disqualification, it mentions the ground for disqualification of members. Office of profit, if he is adjudged insolvent, if he is of unsound mind, if he is not a citizen of India, all these have been mentioned under the disqualification or the grounds for disqualification. And Article 103 of the Constitution mentions, here in brackets you can write Article 103 and Article 192. Article 103 and Article 192. So under Article 103 it has been mentioned what is the procedure of disqualification. Article 102 deals with grounds for disqualification. Article 103 deals with procedure for disqualification. Similarly, Article 192 also deals with procedure of disqualification. It says on the Election Commission, the President will disqualify on the recommendation of the Election Commission, or the Governor will disqualify on the recommendation of Election Commission. Clear? These are constitutional duties. When we talk about the Election Commission, these three functions that you have mentioned, that is superintendence, direction and control, or for that matter conduct of elections, or for that matter recommendations to disqualify. These are what? These are constitutional duties or the constitutional functions that the Election Commission performs. But there are some other functions also that the Election Commission performs. What are those functions? Just add it here. Next point. Registration of political parties. Registration of political parties. Registration of political parties. When it comes to registration, who registers political parties? Election Commission. Next. Recognition of political parties. Recognition of political parties as national and state parties. As national and state parties, and allot symbols to political parties. Allot symbols to political parties and independent candidates. Symbols to political parties and independent candidates. Clear? So even recognition of political party as a state party or a national party, this is something that is done under the Representation of Peoples Act, and the Representation of Peoples Act explicitly mentions what is the criteria on which a political party is to be declared as a state political party or a national political party. So Representation of Peoples Act says that if a political party gets more than 4 seats in the, at least 4 seats in the Lok Sabha, or 6% of the total votes, or if a political party gets, there are some criterias that have been mentioned, and on the basis of those, on the performance of those, on the electoral performance that is done, on the basis of that a political party is categorized as a national political party or a state political party. When a political party is recognized as a national political party, it gets some special benefits, like it gets a symbol, and that political party, that symbol of that political party then becomes, it belongs to that political party, which means no other individual or no other political party can use the same symbol of that national political party. Every national political party gets some free time on the state-run communication networks such as the All India Radio or Doordarshan for their political advertisement. They get free time. It's free from any cost. They get that particular time. They also get what you can say exemption from income tax when it comes to any donation that is received by the political party. It is exempted from income tax, and the political party, national political party also gets, the national political party also gets they get subsidized land, land at very subsidized rate to do what? To open political offices in very prime locations. They get that land as well. So these are benefits that are derived by a national political party. How many national political parties are there in India? Yes, 6. Which are those national political? Has a political party very recently been declared as a national political party? When I say recently, I mean in the last 3 to 4 years. Any political party? No. See, on one electoral performance, it is not done. Like Aam Aadmi Party did have 4 seats in the last Lok Sabha, but this year they were able to get only 1 seat in the Lok Sabha. So it's not generally done after every elections. The Election Commission waits and sees the performance. Trinamool Congress. TMC has been declared as a national political party. I think it was in 2015 or 16. It was declared as a national political party. Otherwise, you will find obviously the Indian National Congress, the BJP, then there is the BSP, then the two left parties are there, NCP, and one of this TMC has been given that this particular status. I don't think Samajwadi Party has the national political, they are not recognized as a national political. BSP has been recognized as a national political party. Clear? So this is the, no, these are the functions. One more, just add here one more function. The Election Commission also expresses its opinion on a case of persons found to be guilty of corrupt electoral practices, which appear before the Supreme Court and High Court, that are referred to the Election Commission of India, on whether such a person should be disqualified, and if so, for what period? Now give a subheading and write powers of Election Commission. Functions we have seen. Let's also look at something, an additional idea here. Powers of Election Commission. During this general elections itself, in the last phase of general elections, because of the violence that was continuously being happening there, the Election Commission did what? The Election Commission evoked Article 324 and suspended campaigning of elections. That is, the campaigning generally ends when? The campaigning generally ends 48 hours before the elections. That means there is a gap of 1 day. If the elections are scheduled to be held on Sunday, so the election campaigning will end on Friday. And on Saturday also you can take up election campaign, but you cannot organize something called as election rally or something like that. You can do what? Door to door campaign. You can move from door to door and you can take up that campaign, but you cannot organize any kind of rally or something like that. So in the last phase of elections, when elections were due, in some constituencies of West Bengal, and some other constituencies also, it was due there, and because of the violence that was going on in West Bengal, Amit Shah, he visited West Bengal, and in his rally there was lot of disruptions. People started burning cars, etc., vehicles, and destroying public property. All these things happened, and that is the reason why the Election Commission did what? Election Commission, newspapers mentioned this. Election Commission evokes Article 324 and does what? It suspended the campaigning of elections 1 day before it was scheduled to stop. That means if elections were to be held on Sunday, it stopped the election, this campaigning on Thursday itself rather than on Friday. So what is the meaning of this idea? Evoking Article 324. What is the meaning of this? The newspapers, if you go back to that, if you see the archives of newspapers, you will find that in almost all the national daily, this was the headline. Election Commission, EC evokes Article 324 and suspends electoral campaigning, ends electoral campaigning. What does this mean? Evoking Article 324. What does that mean? What is the meaning of the term evoking Article 324? Yes? To use it. Okay. So why are we saying that Election Commission evoked Article 324 and stopped the election campaign one day before it was scheduled to? What is the meaning of this? See, in functions you have mentioned superintendence, direction, control, and second, conduct of elections. When we talk about the power of Election Commission, if you look at the Supreme Court's decision or the Supreme Court's interpretation of what is the meaning of these terms, superintendence, control, conduct, direction, what is the meaning of this term? The Supreme Court is of the opinion, in one of the cases, Kanhaiya Lal Omar versus some Trivedi case was there, SK Trivedi or something. In this particular case, 1985, long back ago, 1985, the Supreme Court declared that the term that is mentioned, that is superintendence, control, conduct and direction, the term will have the widest possible meaning. The Supreme Court has to say it has the widest possible meaning, and the Supreme Court can, with the Election Commission can, with respect to control, superintendence and conduct of elections, directions and conduct of elections, the Election Commission can take any of the steps, including certain executive actions, which can be done, and it is only the powers that the Election Commission has is subject to only two conditions. First, if there is a limitation to that power that has been mentioned in a law that has been enacted by the Parliament or state legislature. So if the law, if whatever the Supreme Court, whatever the Election Commission does, if that the powers that are exercised by the Election Commission, if those powers that are exercised by the Election Commission, they are restricted under a law made by the Parliament or state legislature, that will be a restriction or limitation to such powers. Second, the principle of natural justice. That means any action that is taken up by the Election Commission should not contradict the principles of natural justice. And except for these two limitations, the interpretation of the term direction, superintendence, control and conduct will have the widest possible meaning. So the Supreme Court evoking Article 324 of the Constitution means this, that the Supreme Court has evoked its power to do what? Superintendence, conduct, control, election. When the Election Commission evokes this, that Article 324, it means Election Commission has just evoked the power that it has under Article 324, which is direction, superintendence, control and conduct of elections, and accordingly the Election Commission can direct any individual, any institution or any authority to take up any of such actions. It can do that. It can do that. This is what is evoking Article 324. No, Article 324 of the Constitution. You must have also seen that during this general elections itself, in fact, during every elections, as soon as the elections are announced, like this week itself, elections to Delhi legislature has been announced. This last week, Delhi legislature elections have been announced on 8th of February, and there will be results will be announced on 11th of February. So till 8th of February, since as soon as the Election Commission announces the the date of elections till the conduct of elections, what is in place is something called as Model Code of Conduct. Model Code of Conduct. And it basically is what? It talks about certain conduct rules for every political party and for every candidate contesting elections. There are some conduct rules that are imposed. There are some conduct rules that are imposed and it cannot be violated. These conduct rules cannot be violated. If it is violated, what will happen? If it is violated, there will be a punishment that will be attached to it. And in this case, the punishment can be given by the Election Commission itself, not necessarily by the courts. It can be given by the Election Commission itself. Like an example, if you have a vehicle and today you do what? You put a political party's sticker on that vehicle, that will be considered as that vehicle, and you putting up that sticker and suppose driving that vehicle, that will be considered as a form of campaigning. That will be considered as a form of campaigning, and your vehicle may be seized also. If you do not follow the conduct rules, it may be seized and it will be returned to you after elections. That is, after Model Code of Conduct is over. When Model Code of Conduct is in operation, you cannot transfer a lot of cash. There is a limit to which to the cash that you can carry. It is 50,000. If you carry even 1 rupee more than that, it will be seized and it will be returned to you after elections. Now, you must not have read this in the newspaper, but recently, I think it was Friday or Saturday or Thursday, there was an individual who was caught in the Delhi metro with 20 lakh as cash. That's not a problem. You can carry that amount of cash. If it is not an illegal money, it does not matter. But that money was seized by the DMRC. Why? Because Model Code of Conduct is in operation. You cannot carry cash worth more than 50,000. If you are caught with it, automatically it will be seized. Similarly, during elections, you will find that general elections, in this case, Mayawati and Yogi Adityanath, both of them were banned from electoral campaigning for around 48 hours for Mayawati and 72 odd hours for Yogi Adityanath. That is a punishment, a penal action. Who banned them? Was it the court that banned their they speaking? No, it was the Election Commission. So when we talk about superintendence, direction, control and conduct of elections, the Election Commission enjoys widest possible interpretation of this term, which means not only the Election Commission has executive powers. In this case, the Election Commission even has some quasi-judicial powers. And when we say punishing an individual, like when we talk about censoring Mayawati or Yogi Adityanath, it is what? It is a punishment, it is a penal action. And based on separation of powers, theory of separation of powers, this is not to be taken up by an executive body. It is under the domain of judiciary. It is under the domain of judiciary, not under the domain of any executive body, but still it is taken up. It is taken up by such bodies as well. Why? Superintendence, direction, control and conduct, these terms have the widest possible interpretation. This is what the Supreme Court has to say in the Kanhaiya Lal Omar versus the R.K. Trivedi case in 1985. Clear? So when we say evoking Article 324, this is what it means. This is what it means, and there are only two restrictions on it. If there is a law that has been made by the parliament restricting the election commission not to do something, or for that matter, if the procedure that has been adopted by the election commission, if it is violative of principle of natural justice, only in these two cases there are limitations that are imposed on the powers exercised by the election commission. Only then. Like, as an individual, if suppose I am above the age of 18 years, so I have the right to get myself registered in the electoral roll. Who has the power to prepare this electoral roll? Election Commission. So the Election Commission has the right to either include or exclude me. And it can do that. It can exclude my name from the electoral roll also, provided principles of natural justice are not being violated, which means if I am being punished for whatever reasons, the three principles that we had talked about. First, audi alteram partem, no one shall be punished unheard. Second, authorities will act in a bona fide manner, not in a malified manner, with good intention. And third, no one shall be a judge in his own case. If these three provisions are fulfilled, it is the discretion of the election commission. The election commission can accordingly provide that. So election commission has wide rights because of this. Like, you must have heard about the election commission coming out with certain limits of expenditure. That when elections are being conducted, so for every state and for every general elections constituency, there is a limit that is imposed on the expenditure that is taken up by an contesting candidate. तो मैं तो इलेक्शन कमीशन को बोल सकता ना, मेरा पैसा मैं उड़ाऊं, तुम्हें क्या? But that cannot be done. It's my money. If I am contesting elections, so I can do that. It's my money. But the election commission has imposed restrictions on it. Why? Because it has the power of direction, superintendence, control and conduct of elections. It has that power, and accordingly it can come up with such limitations. Clear? This is the power of the Election Commission of India. Clear? Write this. See, it is for political parties, it is for candidates, and it is for all those individuals who take up campaigning for political parties. So if I have suppose used my vehicle, basically I am campaigning for that political party. So that will be all of it is there. So it will be the election commission may stop it or direct the concerned authority. It will stop it. It will write my vehicle's name, and that may be used in actually calculating the expenditure of that has been conducted by an individual. It will be a part of it. So if you come up with any such thing, so an individual might not know, okay, ये इसने भी गाड़ी में मेरा फोटो लगाया हुआ है, but that will be calculated as an expenditure taken up by the particular individual. It is completely up to the election commission. In Kanhaiya Lal Omar versus R.K. Trivedi, 1985 case, the Supreme Court held that the Election Commission of India under Article 324 clause 1, under Article 324 clause 1 enjoys wide powers, the expression, superintendence, direction, control and conduct of elections, shall have the broadest meaning, and the election commission enjoys penal powers under Article 324 Clause 1. Penal powers under Article 324 Clause 1. Such power cannot be controlled by the executive, and it is only subject to two limitations. First, the parliament or the state legislature has enacted a valid law relating to or in connection with the election commission. However, if a law is silent or makes insufficient provisions, the election commission has the power to act to ensure free and fair elections. Second, the Election Commission of India shall conform to rule of law and follow the principles of natural justice. And the acts of the election commission is subject to review on these grounds. This is the power of the Election Commission of India. With this, we have completed our discussion on part 15 of the Constitution, which deals with elections. Clear? Next, yes.
Review as in judicial reviews?
Review means obviously judicial review. Yes, in Supreme Court. The review can be done not just in Supreme Court but even in High Court. Judicial review is always related to High Court and Supreme Court. But it depends upon the case. If it is related to, suppose, if it is related to a particular constituency, so it can be appealed in the concerned High Court as well. If it is about the decision of the Election Commission with respect to, suppose, an electoral law which is made by the Parliament, now then it is subject to Supreme Court. With this, we complete our discussion on elections. Here, obviously, there are ideas such as some electoral laws are there, like Representation of People's Act. I have discussed some provisions of the Representation of People's Act, and in further course of our discussion, I'm also going to come to the other provisions. So I might not deal with the electoral law separately because all the important provisions I might have discussed even before that. Clear? Next comes to let's come to center-state relations. Let's look into center-state relations. Give this particular subheading: center-state relations. Yes. Last class, what did I say? For electoral reforms, did I tell anything about it? Electoral reforms. I said I will be dealing with it when I come to governance. So let's start with that. Center-state relations. Center-state relations. See, center-state relations, to understand this, center-state relations, let's start with this idea of the different kind of political structures that are present across the world. Basically, whenever we talk about political structures, I might have discussed this earlier also, but again I am repeating this. There are basically three kinds of systems or three kind of structures that you will find. First is the unitary structure, which means that when unitary structure is in place, there is no division of powers. That means in a unitary structure or in a unitary state, the union is all powerful. The union is all powerful, though there may be some geographical subunits that may exist. Some geographical subunits may exist, but the powers that are enjoyed by these geographical subunits may not have a constitutional guarantee, may not have a constitutional guarantee. That means powers that are allocated to this geographical subunit. When I say geographical subunit, what does that mean? States. In India we call it state, somewhere it may be called as provinces, etc., etc. Depending upon that particular country's lingo, what they use, language that they use. This geographical subunit that is there, in India these are known as states, and these powers that are enjoyed by these geographical subunits in a unitary state, they may enjoy some powers, but these powers may not have a constitutional guarantee. Okay? They may not have a constitutional guarantee. So generally you will find that it has been defined when you look at various books that are there, they tend to define unitary state as a state wherein there is no division of powers. That is not an accurate definition of what unitary state is. Unitary state means that there is a state wherein the union is all powerful, and though there may exist some geographical subunits and these geographical subunits may enjoy some powers, but these powers may not have been constitutionally guaranteed to them, which means it can at any given point of time taken away by the union. It can be taken away by the union. Clear? The second is a federation. The second kind is a federation, and in a federation, this is a very different, this is implemented in a very different manner. That means here there is division of powers, and this division of power is constitutionally guaranteed. This division of power is constitutionally guaranteed. This division of power is constitutionally guaranteed. See, when you are going through Lakshmikant also, you will find that they have also tried to explain this in this manner, that there is a table that they have drawn, and in this table on one hand they have mentioned what are the features of a federal state, and on other hand they have mentioned what are the federal features of a unitary state. And when you are seeing the features of the federal state, you will find it has been mentioned written constitution. It will be mentioned there, written constitution or rigid constitution. Why are we saying rigid constitution? What is the logic behind it? The logic behind it is this, that the powers that are given to the geographical subunit, it is constitutionally guaranteed. So it is not easy. When rigid constitution is there, which means what? It is not easy to take away these powers. Hence, this division of power will exist. This is what it means. This is what it means. Then there is a third type also called as confederation. This is in existence in example the European Union, or for that matter the Caribbean islands. The Caribbean islands. These are the two examples of the confederation type, which means here every geographical subunit, is sovereign. They are sovereign. Clear? So in EU, again last week itself, UK, they have passed the Parliament of UK has passed this the EU Brexit idea that is there. They have passed it. So now, while deciding this Brexit, that is Britain exiting European Union, did Britain go to the European Union and ask for it? No. Did European Union play any part in it? Absolutely not. It was initially decided by a referendum, and now it has been passed by the Parliament of UK. So every subunit, geographical subunit, is a sovereign authority. They decide for themselves. That is not the case in both of these. If you look at these two, that is federation and unitary state, the geographical subunit that may exist, they are not sovereign authorities. They are not sovereign. Here they do not have any power. Here they have some powers which are constitutionally guaranteed, but they do not have what? Sovereignty. Sovereignty is not there. In confederation type there is existence. Also what is present is sovereignty. Clear? Understood this? This confederation type is mentioned in your NCRTs. If you read your NCRTs, you will find such examples being present there. In your NCRTs, you will also find that it further says even federation is of two types. First is pooling of sovereignty. Pooling of sovereignty. Kind of federation. Then there is division of powers kind of federation. Example of pooling of sovereignty is US. On the other hand, division of power example is India, Spain. These are the examples. In India, we could never have adopted for a unitary state. See, if you look at the powers that the Constituent Assembly has given to the Parliament of India or the Union Legislature, like emergency provisions, we have dealt with emergency provisions. We have also seen Article 1 of the Constitution. We have seen Article 3 of the Constitution. All these provisions we have already dealt with it. So if you look at the Constituent Assembly and the powers that Constituent Assembly had given to the Union Parliament, if India could naturally be a unitary state, we would have been a unitary state. We would have adopted for a unitary state. But we could not naturally be that. Why? Because the territorial extent of India, it would have become very difficult to administer from, suppose, a capital like Delhi and administering the whole of India, or for that matter Parliament making laws for whole of India in all the subjects. It would not have been that easy. And that is the reason why we adopted for what? We opted for a federation which is called as the division of power kind. So we have divided the power that is there into various geographical subunits. India, sometimes whenever we talk about this idea of federation, in India there is a lot of constitutional ideas that we see here we have discussed now, and we are also going to discuss, which points out to that India is not an ideal kind of a federation. We say India's federation has a unitary tilt, and that unitary tilt is visible under Article 1, under Article 3, under emergency provisions, under All India services. All these provisions that we have discussed, when we compare the union with that of the states, we find that yes, though India, yes, there exists a division of power, yes, there exists a constitutional guarantee to this division of power, but saying India will be India is an ideal federation will also not be theoretically correct. It will also not be correct. So because of such provisions, existence of, like right now we discussed the election commission. Now we have only one election commission of India, and that is responsible for conduct of elections even to the state legislature. There is no there is no a similar body that is present in the states. So why not completely give the states autonomy to conduct their own elections? We did not do that. In fact, under Article 327 of the Constitution, the power to regulate elections also lies with the Parliament, and under Article 328, any power that the state legislature has, it will be present only if there is a law which is either not sufficient or silent on electoral matters. Only then the states enjoy these powers, otherwise it does not. So the election commission, organization of elections, all India services, emergency provisions, Article 1, Article 3 of the Constitution, all these things that we see, it points out to the fact that India is not an ideal federation. But yes, India is a federation. Why? We still persist with this idea that, we persist with this idea that India is a federation. We persist with this idea because it was B.R. Ambedkar, our constitution maker, who said India is a federation. He said India is a federation of its own kind. So it's the best way to describe what Indian federation is about. India is a federation, no doubt about it. But what kind of federation? A federation of its own kind. It's a federation of its own kind. Clear? Now, as a result of India opting for this division of powers, we see that the center, that is the union, and the sub-geographical division, which is the states, they enjoy a certain kind of relationship. And this relationship can be categorized into legislative, executive, and financial relations. So when we say division of powers, what is this division of powers? This division of powers exists in legislative sphere. So when it comes to what are the laws or what are the subjects on which laws are made by the parliament, they are completely different from the laws that are made by the state legislature or the subjects on which the state legislature make laws. Similarly, when it comes to the executive or administrative jurisdiction, the union executive enjoys a certain, in certain cases they enjoy that executive jurisdiction, and that is also available to the state executive, but again in certain cases. So you will find that there is a kind of relationship that is shared between the union legislature and the state legislature. Is a certain kind of relationship that is present. Now, when we talk about this relationship, that is whatever functions or duties that the state has and whatever functions and duties that the union has, it also requires some financial powers. That means some power to taxation or division of financial resources. Otherwise, one of them, that is either the union or the state, will not be able to properly discharge their responsibilities and duties. So whenever we talk about legislative or executive jurisdiction, because there is separation of legislative and executive powers, that also results into separation of some financial powers. and that is what happens. There are some legislative divisions, some legislative division of powers, some executive division of powers, and some financial division of powers. So now we are going to look at this very idea, and we are also going to see why is it that we are so persistent about this idea that India is a federation, and why there are some legal experts or constitutional experts which do not agree to the fact that India is a federation. Why is this the case? Clear? Let's start with legislative division of powers or legislative relations. Legislative relations. See, in legislative relations, we are going to stick to what the Constitution provides for. We'll understand what the Constitution provides for. When it comes to the executive powers or administration, that's the idea that is there. I am going to deal with the Constitution. I am going to talk about the Constitution, and I am also going to talk about certain contemporary ideas, certain contemporary issues that are present. Clear? Let's start with the first article, that is Article 245. Article 245. What does it say? Write this down. Article 245 elaborates the extent of laws made by the Parliament and state legislatures. Parliament and state legislature. It states that laws made by the Parliament are enforceable for the whole or any part of the territory of India, for the whole or any part of the territory of India, comma, laws made by the state legislature are enforceable for the whole or any part of the state, Further, Article 245 Clause 2 also states that laws made by the Parliament shall not be deemed invalid on the grounds that it would have extraterritorial operation. Extraterritorial operation. Underline this, extraterritorial operation. So what does Article 245 elaborates? Article 245 elaborates upon the extent of the applicability of law that is made by the Parliament or, for that matter, the state legislature. If we talk about a law that is made by the Parliament, a law that is made by the Parliament is applicable throughout the territory of India, or for that matter to any part of the territory of India. Some laws are not just applicable throughout the territory, it is for a certain part of India also. Like you must have heard about a law, Armed Forces Special Powers Act. It's not applicable throughout the territory of India. It is applicable only to something called as disturbed areas. Clear? Similarly is the case with state legislature. When the state legislature makes a law, enacts a law, that law is applicable not necessarily for the throughout the territory of the particular state. It might be for the state, complete state, or it might be for any specific part of it. But the most important aspect of this discussion is when we see Article 245 Clause 2. When it says, Article 245 Clause 2 says that a law that is made by the Parliament will not be deemed invalid because it has some extraterritorial jurisdiction or extraterritorial operation. What does that mean? What is the meaning of this term extraterritorial? To understand this, let's take an example. Suppose an individual who is not a citizen of India. He is not a citizen of India, he is a citizen of some other country. But he has just performed an act in India which is not considered to be legal, or when it is punishable under the law that is there in India. He will be punished for it. He cannot claim this defense that when I am not an Indian, how can you punish me under a law made by the Parliament of India? I am not under that jurisdiction. This defense will not be valid. Why? Because the individual has performed an act. The individual has performed an act which is in violation of the laws made by the Parliament of India. This also extends to this. There is another idea that you need to get here. Suppose there is a citizen of India. Like in India, we do what? Under laws, we prohibit existence of polygamy. We cannot practice polygamy. Yes, obviously there is different personal laws. So it depends upon personal laws. But for most of the religion that is there in India, polygamy has been prohibited. So as an individual, an individual cannot claim that he is married outside India and he comes to India and marries someone here also, and he says that because I have not married in India, I have not performed this act of polygamy in India, so I cannot be punished under the laws in India. No, you cannot claim that defense. Why? Because an act of polygamy will be an act of polygamy despite the fact that it may not have been performed within the territory of India. It will still be considered an act of polygamy, and whatever legal mechanism is prescribed or penal mechanism is prescribed, it will still exist. It will still be taken up. Clear? So when we talk about extraterritorial operation, this is what it means. You cannot claim this defense that an individual who is not a citizen of India cannot claim a defense that because I am not citizen of India, so I am not immune. No, I am immune from any laws that are made by the Parliament. Or an individual who is a citizen of India cannot claim that because I have not performed an act in India and hence it is not punishable under laws in India. This cannot be claimed as a defense. This is what is meant by extraterritorial operation. Clear? And any law that is made by the Parliament, it may have an extraterritorial operation as well. Like recently there was a controversy that comes up, a controversy with respect to the CAA. Obviously there were a lot of protests. Some protests are still going on with respect to CAA, and in one of the very highlighted cases here was that an individual, an actor called as Farhan Akhtar, he had actually shared a tweet in which there was a map that was present, that portrayed India. The map that was there, it portrayed that the POK region that was there, it was not the part of India. The POK region that is there, it is not the part of India. Now, first of all, that is a punishable offense. That is against the law. There was a law that has been passed, and in that particular law, it specifically says it is a criminal offense. You cannot do that. You cannot in any way change the map of India except for what is the map that has been given by the government. That is what we accept as the political map of India. Whatever geopolitical situation dictates, we are not concerned with that. Yes, POK is not under the administration of India. It is Pakistan occupied, but it does not mean that we have given up our claim on POK. And because that is the case, we still, when it comes to drawing lines or boundaries, we still consider POK as a part of India. Despite the fact it is not under administration of India, it will still be considered as a part of India. Now, he has done that through the use of social media, and he apologized for it. Okay, he apologized for it. There can be a criminal case that can be registered against him, and it can be taken up. Despite the fact that he may not necessarily know the map of India, that is a different thing altogether. Yes, not everyone does that. Okay? We know it, we understand it because we are here. Because if you are not in this in what you do, you are preparing for UPSC, you will find that people in India, they do not know what is the map of India also. They are not very much aware about it. ठीक है, नॉर्थ ईस्ट को भी उधर ही दिखाएंगे कहीं और, अरेबियन सी में. तो that is the case. No, that is the case. First of all, it is a criminal offense. Second of all, if an individual does that outside India and claims that because I have done this outside India, hence I am not punishable under a law in India, it is not correct. That individual will still be punished in India as well. Okay, there are lot of there have been number of cases in which this has happened as well. Clear? So this is what is meant by extraterritorial operation. Clear? Next. Yes. Yes, obviously any individual. See, when we talk about a bureaucrat or suppose an ambassador of India working in any other country, when he is working in that embassy is treated as a territory of India. That means that it may be located somewhere else, but that particular property is treated as that. No, it's not under that particular country's administration. It is treated as all the laws that are there, they are different. That means our laws are applicable there. No, so it is as it is. It is treated as a different territory. No, at all. Like as if you get into this IFS, foreign services. In foreign services, when you get into foreign services, in that case, when you work as an ambassador there, everything that you own will never, it is immune from the laws that are there in that particular country. So, if your car has that embassy signature is there, like they will have a different kind of number plate, and there is a flag that is present, that car is it is treated as a different country. So you cannot be searched. The authorities that are there, they cannot in any way invade that. It will be it will lead to a diplomatic problem between these two countries. It cannot be done under international laws. Next, Article 246. Under Article 246 first 246 clause 1. Parliament has the exclusive power. Parliament has the exclusive power to make laws. With respect to any matter mentioned in Union list in the 7th schedule. 246 clause 2. 246 clause 2. The Parliament and the state legislature have the power to make laws with respect to any subject under concurrent list of Schedule 7. concurrent list of schedule 7. 246 clause 3. The state legislature has exclusive power to make laws on subjects mentioned in the state list of the 7th schedule. Next, 246 clause 4. 246 clause 4. The parliament has the power to make laws with respect to any matter for any part of the territory of India, not included in a state, in brackets right here, residual territorial legislation powers. It simply means any part of the territory of India which is not included as a part of a state. For that territory, who will make laws? It will be the parliament, like it does for UTs. We have 9 UTs. Out of 9 UTs, we have 3 UTs which have legislature, and for the rest, that is the rest 6 UTs that are there, in that case it is the parliamentary laws which are applicable there. It is automatically parliamentary laws are applicable, and parliament has the authority to make laws in case of UTs or in case of any territory which is not included as a part of state, not only for something that is mentioned in the union list, it is also for something that is mentioned in the state list, concurrent list and the union list. Who has the power? It is the union parliament which has the power to do it. Clear? Even when it comes to UTs with legislature, there are some certain subjects which are kept outside the jurisdiction of the UTs. Like in India, when we talk about NCT, you will see that in NCT, 3 subjects: public order, land and police. These three aspects, these 3 subjects which are generally the part of state subject, they are mentioned in the state list. It does not give the power to the Delhi legislature or legislature of NCT to take up or to enact a law in this case. Now you will always find the chief minister of Delhi always claiming, Delhi police hamare paas nahi hai, Delhi police hamare paas nahi hai. Why? Because the police that is there, it does not fall. In this case, in the NCT of Delhi, it is not under the state, under the council of ministers basically, or the NCT legislature. It falls under the union legislature. Similarly is the case with public order. Public order is a broad idea. It includes police. Public order, any law with respect to law and order that is to be made, it is the parliament which will make laws and not the NCT, legislature of Delhi. Similarly is the case with land. Now, if you see documents that are there in Delhi, the documents, like there is something called as leasehold property. Any leasehold property that is there, which means you are not yet given the ownership of it, you are leased. The property has been leased by the state to you. So lease is there for suppose 99 years, and it can be converted also. And if you see the document, the leasehold document that is there, it will be mentioned. The first party would be who? It would be the President of India. Not the lieutenant governor, or in case of states it will be the governor of that state, not the president. But in Delhi it will be the president. Why? Because land is not under the state government and the state legislature. It's not under the state government or the state legislature, because you will see right now during elections both the political parties, BJP will claim unauthorized colony जो है हमने authorize कर दिया, and the आम आदमी party is also claiming the same idea थे हमारी effort की वजह से हुआ, but actually the state government does not, NCT government has no right there. They cannot do it. It is done by the union government. So you will find that they have a modified version of it. Aam Aadmi Party has a modified version of it. They say हमने unauthorized colony में बहुत काम किया है. They will not say that we have actually authorized it, because it's constitutionally not possible. They claim we have worked in unauthorized colony. तो हमने बिजली पानी सड़क दिया है. This is what they claim. ठीक है? This is the basic idea. Clear? This is what is mentioned under Article 246 of the Constitution. So this is where I am going to stop here. Tomorrow we take up the more important ideas. Tomorrow we complete our discussion on center-state relations, including financial relations. And tomorrow's class is very important for you, because when it comes to financial relations, the manner in which I discuss financial relations and those provisions that have been included post the GST amendment. I'll be talking about the constitution post the GST amendment. This is not something that has been updated in Lakshmikant. Okay? So I think it is the recent version. I have not seen that. So if it has been updated in the recent version, so that's a different thing altogether. But otherwise it has not been updated. As it is, Lakshmikant does not talk about an elaborate discussion on something called as the GST Council. I am going to take up an elaborate discussion on GST Council and what is the effect of its the existence of GST Council on fiscal federalism in India. That is what I am going to discuss, which you are not going to find specifically in this book that you read, Lakshmikant. Okay? Thank you.